Thank you, Senator. Mr. Brown.
Thank you very much, Mr. Chairman, Senators. It's an honor to have been asked to come to this committee today, along with Senator Runciman and New York State Senator Ritchie. As Senator Ritchie outlined, we've had a number of meetings about this issue over the last number of years. It should also be noted that I have a similar bill before the House of Commons as a private member's bill, which is a little further down the order of precedent. So we're hoping to see that this bill gets passed through the Senate and then moving, of course, through the House of Commons. And the sooner that this can happen, the better, hopefully, for this boating season. Now, Senators, this bill before us today serves to amend regulations which are not grossly disproportionate to the goal of protecting Canadian people, but also harmful to Canadian principles of legal fairness and detrimental to the small businesses which constitute the backbone of our tourism industry. It's important that we make these changes now to ensure that our legislation reflects the needs of Canadians today rather than nearly 90 years in the past when this legislation was created to stop the smuggling of alcohol between our nations. The United States has made great progress in developing regulations which not only serve to promote easy travel between our countries, but also to effectively protect their country from any potential risks on the water. Canada has yet to strike that same balance, as our own laws are so strict that they have caused many American citizens to conclude that travel to Canadian waters is simply not worth the risk nor the hassle. The punishments imposed on individuals found in Canadian waters would be considered severe even if the regulations were well known to United States citizens. Unfortunately, that's not the case. On a regular basis, Americans enter our waters with the understanding that they are allowed to do so as long as they do not anchor or come ashore. This is a long-standing practice among fishermen, often passed from father to son, and only interrupted on the rare occasion the Canadian Border Services Agency happens to come upon an unreported vessel, as we've heard about in the incident from a few years ago. In such instances, despite not knowing that they were breaking the law, these individuals are faced with the immediate and potentially permanent seizure of their vessel, humiliating physical restraints, fines of $1,000 to be paid on the spot, as well as other fines that can range as high as $25,000. What makes this worse is that this degrading treatment often occurs after the CBSA has determined that the individuals in question have no outstanding criminal record and have no reason to believe that they pose any risk to Canada. This behavior constitutes a clear violation of the legal principles which the Canadian people have come to consider a fundamental aspect of judicial fairness in our country. This includes concepts so important to us that we enshrined them in the Charter. The right to life, liberty, and security of the person, the right to be secure against unreasonable search and seizure, and the right not to be subjected to any cruel and unusual treatment or punishment, including the excessive use or abuse of force by law enforcement officials. These laws were carefully crafted to ensure that no one would face discrimination in Canadian territory, and yet we are so quick to ignore them for something as benign as a fisherman on a day out with his family. It's a disgrace, and our Charter deserves more respect than that. And while the Supreme Court decision in Simmons acknowledges that our right to control who and what crosses our boundaries, it does not excuse the poor treatment some have received. While the measures used may have been defensible and even necessary when dealing with larger crafts and cargo carriers, they serve no purpose in regulating small vessels. Any fear of risk should already be dispelled by the fact that the United States has allowed the easy passage of small crafts for a number of years without issue, and the fact that American pleasure crafts are already in our waters without causing any trouble to the Canadian people. Beyond the moral and legal implications of our current legislation, we should also take time to consider the impact it may be having on the Canadian tourism industry. A number of Chamber of Commerces across Canada have expressed their concern that these incidents on the water are harmful to their marketing efforts, and I have had communications from folks in other border areas where there's boundary waters, such as in the Sarnia area and in the Kenora area, as well as in Western Canada. Now, while they and many small tourist businesses work hard to present Canada as a friendly, welcoming, and fun place to visit, the press in the United States has repeatedly declared that the regulations in question are a testament to the fact that we do not want American visitors at all. In my own riding of Leeds-Grenville-Thousand Islands and Rideau Lakes, we have already experienced multiple incidents as a result of the current legislation which have caused negative stories to circulate. This is particularly concerning given the fact that the tourism industry creates more than 1 million jobs, often providing employment for youth and immigrants as well, who have historically had difficulty in finding and maintaining steady employment. Canada should be doing everything possible to promote our natural beauty, rich history, and cultural diversity to the world, not only for our benefit, but also to grow our international relationships, especially with our neighbors in the United States. The proposed amendments in this bill are beneficial to all parties involved and are long overdue. It's time to do away with these regulations that do us no service. I look forward to this committee passing this legislation back to the Senate, and then hopefully we will see it in the House of Commons as soon as possible. Thank you very much.
Yeah, that's